Hey, so welcome back to Dumb Defenses, where we are digging through history for the weirdest legal theories and bringing them to you.
We're kind of just doing whatever.
We are kind of just doing whatever.
It's like there's got to be some weird legal shenanigans happening, and then we're gonna talk about it, and that's what it is.
Yep.
Uh, I've got a good one for you.
Okay.
Good one
I
for.
will say, I may have oversold the lover's quarrel portion of my case when I was teasing it last week. It was kind of a one-sided lover's quarrel.
I mean, whomst among us has not had one of those? Well, you went first last time. Do you want me to go first this time, or do you want to go
Go
first?
for it.
All right. So I'm going to talk about. I actually used real sources. The first one that I recommend to everybody, it's free on Project Gutenberg, is The Criminal Prosecution and Capital Punishment of Animals by E.P. Evans, a book
Okay.
from 1906. It has got so much more than we're digging into today and is absolutely fascinating. I also referenced When Society Puts Animals on Trial by Sonia Vatomsky, at Vermin Trials by Peter T. Leeson, and the Drunk History Animals episode. The person's drunk as a skunk, and it's not accurate, but it's like super, super entertaining.
I love drunk history. It
Yeah,
is so fun.
it it is very fun. There's a lot that they get wrong, but also this person is hammered. I mean,
Mm-hmm.
for being that hammered, I thought they did a pretty good job. Uh okay. All right, Frank. So it's 1508. Picture this. It's 1508. And you are a highly trained jurist, recently made crown attorney for the bailage or the bailiff for Autun in France. And then one day the Catholic Church calls you up and informs you that they have a mandatory good deal for you. You have just been appointed as a public defender. This is old school public defense system.
You went in the way back machine for this one.
Yeah. For all of the rats in the region.
What'd the rats do?
They are charged with eating stockpiles of the community's barley.
That's kind of the job, but okay.
All right. So, I mean, just before we dig into this, what are some concerns that you have?
Well, in modern law, animals are property, not people. So
Yeah.
I'm not entirely sure how you're charging property with a crime.
So, at this point, animal trials have been going on like pretty regularly in Western Europe for about 300 years.
Oh, wow.
This was not this was not a new thing. There are many theories as to like why this was happening and how it was happening, and these cases are really interesting because they're a combination of common law like defense, and only common law because that's all that existed
That's, yeah.
for the common people. Common law defense, philosophy, and theology. I couldn't actually find any arguments where somebody straight up was like, "But it's a dog, right? But it's a dog."
I mean,
um,
that was my first thought, but
yeah, but it's a rat, but it's a freaking rat. I mean, there were eels, locusts, weevils, pigs, bulls, pretty regularly brought to trial, and they are brought to trial not just in the ecclesiastical
did they
court.
put them in shackles?
Yeah.
Itty bitty shackles?
Okay, all right. So, well, I mean, I can start with the earliest, like, good record is of a pig and her piglets. So, a sow and her piglets facing a charge of murder for murdering a child in the street. The sow is convicted, dressed in people clothes, and hung from a tree.
Why? I mean, I get it. Like, pigs are kind of vicious, but
They didn't just kill the pig, this was a civil trial. So these aren't just taking place in the church. This is also taking place in the civil courts in the region, like
oh my god.
with the magistrate authority and the bailiffs. Uh, that was about 300 years before. So why do they think animals are culpable? We do not have enough time today, and I really dug into this. But the long and short is first, the common sense reason people lived really closely with animals. They were a part of daily life. They were a part of the home. And so people saw less separation between themselves and animals.
Okay.
So they were more willing to accept that. And there was a prevailing theory about people's souls, going back to Aristotle, the triumvirate theory of the soul.
Hmm.
And there was a belief that animals had at least two of the three parts of what it takes to have a soul. This pig was accused of murder, put on trial, slapped in a dress, hung from a tree. Piglets were actually let off scot-free. They let the piglets go.
Well, I mean, kids are less culpable.
No, it wasn't about culpability. There was just no evidence that the piglets had independently participated in the crime.
Okay.
Uh,
So we're straight up treating them like people.
Yeah, but sort of. And then there's some really interesting arguments going in. There's good lawyering happening in here. So there's arguments as like if we're treating animals like people, if we're accepting that they have the culpability of people, that they should have the same rights as people. And
Hmm.
that's not accepted either. And then there's differences between higher levels of creatures and lower levels of creatures. This made me think when I was reading back, do you ever remember hearing the story of Xerxes the First of Persia, who got really mad at the ocean for destroying some bridges that he was
Oh,
building?
yeah, 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 yeah.
And then he ordered that the ocean be whipped and like
Yep,
dumped a bunch of chains in the ocean.
yep.
This made me think of that and to
Hmm.
think about the law as at its core being a societal demonstration that order can be maintained
Hmm.
and that the authority has the ability to maintain that order.
Hmm. Yeah.
But it's so weird, right? It's so weird.
Yeah, because you, like, they're feral animals. They don't have, like, forebrains the way we do.
No, the
It,
idea of culpability, like it was all about the soul and marks on the soul, and
hmm. Yeah, they didn't understand neuroscience the way we do today.
they didn't, and the way that they experienced and saw the world, like these people are not less intelligent than us. They're living in a completely like different philosophical period,
Right.
and so they're thinking of like what controls the world and still thinking in ways of like animism, like we're pretty close to animism, like beliefs in animism
Hmm.
and spirits and demonic presences and literal presentations of good and evil. So this is a very churched region, but nobody's literate basically.
Right.
and and everyone's living in these really small communities, and you see different communities like producing different types of prosecution. Paul Leeson, who I mentioned, was able to track that you can see influxes of prosecutions of animals a little while after influxes for prosecutions of witchcraft.
Okay.
And he has a theory that this was to like get people to tithe more, like you need to come to church, you need to pay more, that they're exerting control. Just looking at it plainly can also be a demonstration of like people really trying to exercise some level of control over the chaotic environment that they are living in.
Yeah.
All right, so let's get back to this rats case. Back to the rats. The attorney that's appointed is named Bartholomew Chassenet,
Okay.
and he is a very well trained jurist who's just come back from overseas, from abroad, because of the plague. He's appointed as crown counsel. He's very high up, and so they bring him in for this rat trial. Now, does this guy phone it in for his clients? No. This dude's a baller. He is the public defender's public defender, and he goes whole hog. So the trial's in three parts, and I'm really sad that we don't have the record of the third part. We
Oh.
only have the record of the first two parts of the trial, but they're both gold. So part one of the trial, they're there, they're in the cathedral, they're having this trial, and the rats don't show up.
Because they're rats.
Because at the end of the day, what we know is that they are rats. But Chassanet, there's no part of common law that says he can go up and argue like my clients are not here because they're literal rats.
Right.
He can't do that. So he gets up there and argues something that you and I have both argued in court, that the summons was insufficient. You cannot make a ruling against my client. Your summons was insufficient. You posted one summons. Rats are, you need to serve every rat in the region. If you're charging them as a group, then every rat must be served.
No joke, I'm going to make one of those arguments on Tuesday.
We have both done it. I've done it this year. You've done it this year. Summons was insufficient.
Right.
And the church agrees with him. And they say, okay. So the church sends out a notice to all the smaller churches in the region, and they force every single church in the region to be serving summons to the rats from the pulpit. So they're up there preaching after their service, and like, P.S. to all the rats, you have to go to the cathedral. And
Is it sufficient summons if there's no actual, like, paper?
well, nobody could read.
Oh, that's fair.
And especially, you could argue people don't read. You could argue rats don't read. So said, okay, everybody has to go to church, including rats. Ha ha ha. So the rats can all get their summons when they all go to church.
Because that's what rats do.
That's what rats do. That's a baller move. Guy wins round one. I mean, for rats being accused of eating barley, he's doing pretty good so far. Round two.
Yep.
Once again, our defendants do not arrive en masse to their appointment for their ecclesiastical prosecution. And Chassanet knows that... Sorry, it's hard to read this without laughing. Chassanet knows that his clients are facing either excommunication from the church or being declared anathema, which is kind of like meaning you're very, very cursed, you're banished.
Mm-hmm.
And he knows what that's going to mean to the rats, which is functionally nothing because, once again, they are rats.
Right.
But he's still going to get up there and argue. He's going to prove his case. He goes in and says, you cannot continue this because agents of the church would maim or murder my clients on their way here, and we cannot guarantee them safe passage. In this case, the agents of the church are cats. So here we got cat agents of the church. These agents of the church are going to prevent the safe passage of my client from wherever they are to church, and we don't force people to show up to court if they could be seriously injured or killed by coming to court. And the church goes, you know what? You're right. And so part two, he wins again. The rats are not convicted. We don't have a part three. Drunk history says that it's because part three was like the records were destroyed by pests. That's actually a different case, which is hilarious. It's this long back and forth prosecution about weevils, and the judgment page was eaten away by weevils. It's a different case, still hilarious.
Was that a case where the weevils were the defendants?
Yes, the weevils were the defendants.
And then they ate the judgment.
Yeah. And
that's one way to do it.
So this guy, Chassanet, goes on to be a very important figure in French jurisprudence. He writes a book on French common law, which was widely used and informed a lot of the way that people understood the law in France and the development and implementation of the Napoleonic Code. He was on the parliament in Dijon, and this is a Catholic country. Later, he's part of a group that condemns a small Protestant community of about 80 people. And then somebody reminds him of this rat case, and he uses it as a basis to go back and try to defend this community of 80 Protestants. And for a while, he wins that using his own case with the rats as a basis and convinces the
He's
king.
citing himself.
He's citing himself, he's
I love it.
arguing it. This is a successful case that these actual human people who are being persecuted cannot have safe passage to church court, so we can't convict them. For a while, he's successful. Then Chassanet dies, and the king burns the community to the ground.
Mm.
I wanted to bring up just some fascinating things about why the church might have been so willing to not make a ruling on this, to not exercise their power. We see the power of the ecclesiastical courts, so the church courts
Hmm.
specifically, being used for things like swarms of things, acts of God. So they don't have the power to kill somebody. That's the civil authority.
Interesting.
So they have excommunication and declaring things anathema slash like banishing them. And historically, there's quite a few cases of them like convicting and banishing already migratory species that were going to leave anyway.
So they felt really powerful when they
Yeah.
up and left.
Well, they knew that like this is going to be fulfilled. This very early recorded use of this power of banishing is a bishop in the 800s. There's these eels that are plaguing people and they're keeping them from being able to wash their clothes and take baths in the river. So he goes down and he does this like cursing thing on these eels. He goes down, he does a big fancy banishing of the eels, and the eels go away. And the people are super excited because he's banished the eels. Eels are a famously migratory species. Locusts,
Also
famously
very
migratory.
migratory.
Yeah, so a lot of these, they were going to leave anyway. The rats are going to stick around.
Hmm.
I mean, they can't just be like, hey, look, we did it. We did it. We banished the rats. The rats were going to be like, the locusts were already going to leave. The eels were already going to leave. The
They
weevils,
sort of,
they're going to
yeah.
move on.
Rats find a place and they settle.
Yes. And that wasn't discussed like as a theory as to why the church was willing to keep extending this, but that's my theory
Okay.
is they had to take this up. The church did as a demonstration of power, but they knew that they couldn't. But at no point did this matter to any rat in the
No,
entire region.
they were completely oblivious to whatever was going on.
Correct. And so the church had to, it was a good way for the church to save face. If you have other questions, I went way too deep on this.
I'm just like, I'm still wrapping my mind around that whole, like, holding animals accountable for doing animal things. I mean, it feels like the whole, like, argument that you have in juvenile court quite often that's like, we all did this shit as kids. Why are these kids getting in trouble for it?
Well, and in juvenile court, I cannot argue that a child is unable to aid and assist because of their youth. I have
You
to have
should
a,
be.
yeah,
They have
no,
to have a qualifying mental disorder.
I have to have a qualifying mental disorder. It's not just like my client's too immature. So it's like if I'm working with an 11-year-old, the psychologist is going to be like, you know what, they've got an adjustment disorder. And as a result of the adjustment disorder, in
Yeah.
combination with their significant brain immaturity, and that's a farce. Like that's a legal fiction that we're playing out in court, and
I mean,
everybody knows.
anybody can get diagnosed with an adjustment disorder, right?
Yeah.
But that actually transitions really well to my case. So this is R.V. Raby. It's from the Canadian Country Court from 1980. So this starts out a couple of college students taking geology at the University of Toronto. The boy had never dated any girl for any length of time and had minimal amount of sexual experience. He's also an introvert and infatuated with the girl who is the subject of the case, who is active and outgoing. Okay. So they're kind of study buddies at one point while they're studying their geology course. She like goes to the bathroom or something and he digs through her notebook. Um
He sounds like a stage 5 clinger.
a little bit. And so he found a note to one of her friends that she hadn't torn out and given to the friend yet, saying, and for some reason, all the guys I know want to go out with me and not be just friends anymore. So I can't talk to them. I don't want to go out with them, and they know it. So there is static in the air, which is why I want to leave. Hell, I can insult Wayne, who's the defendant in the case. I can insult Wayne and Rick, and they still bug me in class. I want to be alone or just with one good guy, not with a bunch of nothings. So this was meant to be given to one of her girlfriends, just kind of venting or, journal entry or whatever. He stole the page out of the notebook and brought it home and studied it and marked it up with a pen. And
This dude sounds creepy.
a little bit. Yeah, a bit. So they're in geology class. They're allowed to take samples out of the lab to bring home to study. He picks a sample of galena, which is a lead sulfide. It's an igneous or metamorphic rock that comes together in medium or low hydrothermal veins. It has a high specific gravity and a low on the hardness scale. It's heavy, it's soft, and it's kind of like jagged.
Okay.
Like it breaks off at sharp corners.
So it's one of those crystals that could really ward off negative energy if you whipped it at somebody hard enough.
Yes. So, later that day after he borrowed the galena from the lab, he just sort of like happened to run into her. The way it was described, it was very much like air quotes happened to run into her, and arranged to watch squash with friends, again with the air quotes, but nobody was actually playing squash. While they were walking around after they realized that there's not actually a squash game going on, he asked her what she thought of a mutual friend, and she said he's just a friend. And then he asked her what she thought about him, and she said also just a friend. And then he suddenly grabbed her and hit her in the head with the galena wrapped in a cloth. She lost consciousness, and when she regained consciousness, he was strangling her, yelling, "You bitch," over and over. A classmate happened by, and they described the defendant as pale and sweaty and glassy-eyed and frightened. Defendant told him there's been a terrible accident. I've killed her and I'm going to kill you too. A professor saw him afterwards and would describe him as bewildered. His statement to the constable was, really the next thing I remember was I was choking her, and I remember her face was a funny color, and I remember seeing a lot of blood, and then I stopped. He thought he had killed her.
Did he actually kill her?
He did not. He
Good.
was charged with causing bodily harm with intent to wound and some sort of weapons charge for the rock. He forwarded the defense of what's called non-insane automatism, meaning that he was not in control of his actions. He was in a state of dissociation and not capable of controlling his actions, but without an underlying mental disorder. So because he put forward that defense, he was committed to the hospital for testing. He was found to not have any sort of mental disease or defect, and in fact had superior intellect, normal range for personality, and generally utilizes avoidance, repression, and blocking as coping mechanisms. He did not have any signs of disintegration at that point, but his doctor did not rule out any sort of temporary dissociation, which is not uncommon for normal people and not likely to recur. The Crown's doctor disagreed.
Did they say that he was a highly toxic masculine pig who was throwing a hissy fit and beating the crap out of a woman because she wouldn't fulfill the fantasy that he had built up for himself in his mind about what she is?
Sort of.
Hey!
So the Crown's doctor said that this was a controlled young man who was in a state of rage, and if he was dissociative, he suffered the disease of the mind called hysterical neurosis. They opined that he was conscious during the event, but suffered hysterical amnesia afterwards, and that 6 to 12 months of outpatient treatment would leave him with an excellent prognosis. So, the question at trial is essentially whether he was insane under Section 16 of the Canadian Criminal Code, which at base says everybody is presumed to be sane unless proven otherwise. It also says no person shall be convicted of any offense in respect for an act or omission while they were insane. And a person is insane when he is in a state of natural imbecility, is the term that they used, or as a disease of the mind to the extent that renders him incapable of appreciating the nature and the quality of the act or omission, or of knowing the act or omission is wrong. So this is, back from the 80s. This language kind of tracks with our GEI statute here, where somebody, because of a qualifying mental disorder, they're unable to appreciate the illegality of their actions or conform their actions to the law. It's the same kind of an idea.
Well, there's a really important distinction that we're seeing between our law and this law that's really frustrating for me.
Mm-hmm.
So they're saying if you're essentially if you have mental disease or defect or that imbecility.
It's essentially IDD, like intellectual disability. It was called imbecility at that point.
And we've hopefully updated the language, Canada.
Right.
So theirs, it creates more opportunities for having a defense
Mm-hmm.
because here it's not just that you have a mental disorder that caused you to act in a certain way, and absent having that disorder, you would not have done that. It would be that you could not appreciate that what you were doing was illegal,
Right.
and that changes the bar very
Yes.
significantly.
And yeah, there's more discussion about the difference between like the insane and the not insane automatism that gets a little dicey. The other bit of Section 16 of the Criminal Code is that a person who has specific delusions but is otherwise sane shall not be acquitted on ground of insanity unless the delusion caused him to believe that the existence of a state of things that, if it existed, would have justified his act or omission. So essentially, if the only thing the person has is a delusional disorder, or they just have really strongly held beliefs that are incorrect, it's almost like a reasonable person with those beliefs type standard. The defendant is the one who has to overcome this burden of sanity, right? Because everybody's presumed sane unless proved otherwise. But he's not claiming insanity. The Crown is the one pushing the insanity because their doctor says, oh, there's something wrong with him if he reacted that way. So, two main findings at the trial court was that he's not insane within Section 16 of the Criminal Code, and that he acted in a form of automatism brought on by an external cause, which was the girl's rejection, which was what they called a blow to the mind. They discuss internal and external causes of automatism. An internal cause of automatism is some sort of mental disease or defect, whereas an external cause is something that would be like drugs or a concussion or sleepwalking, stuff like that. So the trial court said that this blow to the mind from being rejected by this girl was an external cause of his automatism, and they acquitted him.
What?
So,
Did they make him do any treatment or?
not yet. Essentially, the rule is that you can't commit somebody to a hospital for the criminally insane unless they suffer from a disease of the mind, as their term for mental disease or defect. So, in order to commit someone, they need to have a disease of the mind that is in need of treatment and likely to recur. Since the Crown believed his doctor over the Crown's doctor, it was not likely to recur, so they let him go.
So this pineapple-shaped dildo of a man got off scot-free.
Well, the Crown appealed.
Okay,
So,
good.
yes, the Crown didn't challenge the automatism defense itself, but whether or not he should have been sentenced under the statutes regarding criminally insane. So it's settled law in Canada at the time that transient mental states caused by external causes are not diseases of the mind. Again, that's talking about drugs, concussion, sleepwalking, stuff like that. The disease of the mind excludes self-induced states caused by drugs or alcohol, as well as transitory states like hysteria or concussion. So that was the issue at the trial level, was that the court found that it was a transitory thing, and therefore it was an external cause and not an internal cause. There's also settled law that if there is not an underlying disease, but it's transient unconsciousness and little likelihood of it happening again, the person can go completely free. But if it might happen again, which is suggestive of an underlying disease, then the Criminal Lunatics Act of 1800 controls and the person is committed. Prior to the 1800 Criminal Lunatics Act, if somebody was found not guilty for reason of insanity, they were just like released to their family. A separate like civil commitment could be started, but the 1800 Criminal Lunatics Act made it so that if they're found not guilty for reason of insanity based on a disease of the mind, they are committed for treatment until they are better enough to be released. The settled law is also that whether or not someone suffers from a disease of the mind is a question for the jury. So just like here, if you're putting on a mental health defense, you put on your doctor, the state puts on their doctor. and the jury figures it out. After the 1800 Criminal Lunatics Act, which is what created the ability to force treatment after a not guilty for reason of insanity, in 1883, Queen Victoria wanted and received the Trial of the Lunatics Act, which changed the term to guilty of the act or omission charged, but insane, so as to not be responsible according to the law for his actions. Queen Victoria didn't like the term not guilty by reason of insanity because apparently she was the target of a lot of threats and attempts by mentally ill folk, and so she wanted to make sure that they were found guilty and not guilty by reason of insanity. The idea of automatism, this like your body's doing something and you're not conscious of it, started showing up in the 1950s. And is generally meant to cover situations where you're literally unconscious or otherwise unaware, sleepwalking right after a head injury when your brain's not all there right now, or while under the influence of intoxicants, and essentially means that it's action without conscious volition. And it bridges that standard between the standard insanity defenses, which is, I didn't know it was wrong because I was insane, with these kind of transient hysterical lack of memory. There is some conflicting case law that the Ontario Court of Appeals was dealing with. One case essentially says that if there's a combination of whether it's a mental disease or defect and possibly non-insane automatism, that it's up to the jury to decide. But there's another opinion that says it's error to put automatism to the jury if there's evidence of disease of the mind. So we've got some conflicting case law going on. And there was a case where insanity was found when there was a psychological blow, when the person had an underlying psychotic disorder. And so non-insane automatism was upheld with ample evidence the defendant was not in control of his actions. So there's some conflicting case law in this realm of like, sometimes you can get the non-insane even if you have the underlying defect, depending on how it connects. Sometimes it's up to the jury, it's not up to the jury. This case was going to go up to the country court, like regardless, because there's all this mishmashed case law. Automatism in and of itself is what's called a malfunction of the mind, as opposed to a disease of the mind, because it's essentially a dissociation. And this is going back to the M'Naughton Rule, which had been in place for decades. And the M'Naughton Rule says the jurors ought to be told in all cases that every man is presumed to be sane and to possess a sufficient degree of reason and responsibility for his crimes until the contrary be proved to their satisfaction, and to establish a defense on the ground of insanity, it must be clearly proved that at the time of committing the act, the party accused was laboring under such defective reason from disease of the mind as to not know the nature and quality of the act he was doing. If he did know it, that he did not know what he was doing was wrong. So essentially you can see like this M'Naughton Rule, which had been the common law rule for ages, kind of got incorporated.
Rule in America too.
Yeah,
This is
how that got incorporated into that criminal rule 16 that we talked about earlier. So it's all sort of the same thing. There's this presumption that everybody's sane until proven otherwise, and you have to have either, because of the disease or defect, not understanding that your actions were unlawful, or inability to control your actions in conformance with the law. So the Court of Appeal determined that ordinary stressors or disappointments of life, i.e. being rejected, did not constitute an external cause, but rather an external factor that triggers automatism or dissociative state due to an individual's psychological or emotional makeup. So because of whatever underlying this dude was dealing with, it has to be an insane automatism, not a non-insane automatism.
So the difference here is that they're going to jump around extensively to put this guy somewhere for some period of time because he almost killed an innocent woman.
Yes. Yes. And so essentially, I think it just didn't sit well with the Court of Appeal that this dude was walking free and essentially claiming that I just had a moment, and that there had to be something underlying in his psyche, whether it's some sort of underlying trauma or whatever, that has to have been the basis for him having that dissociative state. And so they said that it had to be an insanity defense. So they reversed it and sent it back down for determination of placement and whether or not it was a continuing issue that would require him to be held and treated, or if it was not. Essentially, they had a concern that he was feigning the automatism.
What?
So he then said fuck that and appealed it to the country court, which is their Supreme Court. This was a case I had to read the dissent first to figure out what the fuck was going on, because it was one of those cases for people listening who aren't attorneys. When something gets up to the higher courts and it's panels of judges as opposed to a single judge, and there's majority and dissenting opinions, essentially people kind of cluster around a couple different ideas. Somebody gets nominated to write the majority and to write the dissent, and then once they're written, they vote. And if it seems like more people are going to be leaning one way or the other, they kind of write that one as the majority opinion. It's more in-depth, it's more explanatory. And then sometimes at the last minute, somebody swaps their vote. And then you have this kind of bare bones skeleton of a thing that's the majority opinion, and then a really lengthy, really in-depth, really explanatory dissent, because that was supposed to be the majority opinion, and then somebody jumped ship. So I think that's what happened here, because I had to read the dissent to understand what was going on. Most of what we're talking about so far has come from the dissent's analysis of what has happened. But the majority opinion essentially said, yep, sounds good. That needs to go back down.
What we call an AWOP. Affirmed without opinion.
Yeah, so the question in front of the country court is essentially whether he needs to be committed to an institution. That's the issue that got all the way up. They found that the disease of the mind is a question of law for the judge, but whether the evidence conforms to that is a question for the jury. So this is pretty familiar to trial attorneys. The judge will charge on what the law is. If you've ever been on a jury and the judge reads you that really long list of what everything means and you kind of zone out and then you get a copy of it because you zoned out, the judge's job is to tell the jury what the law is, and then the jury then takes that information and takes all the facts that they listened to and applies the facts to law and comes up with a solution. So the definition that the court used for automatism is a term used to describe an unconscious involuntary behavior and the state of a person who, though culpable of action, is not conscious of what he's doing. It means an unconscious and involuntary act where the mind does not go with what is being done. So essentially, your brain took a little break, you went and did something illegal, and then your brain came back. The central question on this automatism is whether or not the person is suffering from a disease of the mind, which they defined as a condition or weakness internal to the accused, and it's not transient. So essentially they said a true mental disease is a defense, being pissed off is not. Because being pissed off is transient. Yeah, right? These external blows, which is sort of like what caused this guy's alleged automatism, are to be decided on a case-by-case basis, but it needs to be a serious attack on someone's health or safety, even when they've escaped physical injury or if they've seen like a loved one assaulted. Essentially, the level of external blow that is sufficient for a non-insane automatism is like you literally just escaped death or your loved one is being attacked. That sort of like heat of passion defense type thing that we're thinking about, that's being pissed off, right? This is more than that.
Well, what they're getting to, since we're doing legal analysis, is what we would refer to as voluntariness. The voluntariness of the crime. So if we think about it,
exactly,
like somebody could do something that is a crime, but it's involuntary and it's not because of anything they did. And I think the classic law school example is somebody is driving a car and has their first seizure ever and has no experience, and then they crash their car into somebody else. That was completely involuntary.
That will not carry with it criminal culpability. The Country Court of Canada said being rejected by a girl is not sufficient to substantiate the external blow theory, and the fact that he is putting that forward suggests that he has some sort of disease of the mind.
He's gotta have some sort of disease of the mind. I don't care.
He's got to have something underlying that made him completely dissociate when she said that she thought of him as just a friend.
Because that's got to be a normal event for this guy.
In order for the non-insane automatism defense to fly, it has to be something that a normal person would do. a normal person doesn't dissociate and beat the shit out of somebody when they have somebody tell them they're not that into you.
He didn't just watch her stab his mother. She's like, I don't want to go on a date with you. That's very normal.
Yep. The quote that I pulled was, "It seems to me that his infatuation with this young woman had created an abnormal condition in his mind under the influence of which he acted unnaturally and violently to an imagined slight to which a normal person would not have reacted in the same manner."
Where did this guy wind up, Frank?
So I was not able to find any sort of like news source or anything on it. I did find a really pissed off law review article about it. This case was the first in a series of cases talking about this non-insane automatism defense. This was an article written in the McGill Law Journal by Patrick Healy. And it explains that, again, it's a question of law for the judge to determine whether the jury could find automatism, and that the presumption is for insane automatism unless the situation was so shocking that the normal person would have reacted in the autonomic state, right? Kind of the same stuff we've been talking about.
Like to really what I would think about, like, it sets off your autonomic reaction, your automatic nervous system.
Fight or flight.
Flight. Not tackle someone to the ground, bash her over the head with a rock that you've had to take out of your bag, and then wrap it in a cloth, and then strangle her.
Yep. That's what they're trying to talk about. So this guy who's writing this law review article is essentially saying that any claim of automatism must be considered a mental disorder if the underlying condition presents a continuing danger. Where he gets kind of catty about it is that the courts are applying this air of reality test, which nobody really knows what it means.
I hate to do that.
Right? It's vibes. So he looked at an Ireland case where they used facile mouthing as the standard for something to be put to the jury. Essentially, it can only be put to the jury if it's supported by relevant and sufficient evidence. And due to the court's skepticism of the non-insane automatism, this places a hefty burden on the accused and essentially requires expert testimony. He expresses some concern that it eliminates the defense of the non-insane automatism completely because of the necessity to prove that a normal person would have acted this way.
I mean, like being violent, having a low opinion of women, having an opinion that a woman is there to meet your needs and she is not her own independent person.
Oh, this dude's 100% like incel, like no question. And it was actually like what I love. There was like this stipulated set of facts when it got sent up on appeal. And the agreed statement of facts says the appellant has never dated any other girl for any length of time and had only a minimal amount of sexual experience. He was an introvert and he was infatuated with this girl. Like that was in the agreed statement of facts that got sent up to the appellate court. Like 100% incel. So, wrapping up this law review article, he notes that typically the court isn't supposed to weigh the evidence, so it doesn't step on the jury's toes. But the standard the automatism defenses require that the judge determine whether or not it can even go to the jury, right? So the judge has to be able to have enough evidence on the record to say, yes, you can have this defense. Because ultimately, the judge decides what jury instructions get rendered. Some of the cases that came after the case that we're talking about said it would be error for the judge to not make that factual determination prior to sending it to the jury. But this guy expresses concern that with the judge determining this, on the cloud of a sweepingly wide definition of mental disorder, which may or may not comport with expert testimony, can cause chaos on cross-examination. Right? So, like, essentially, with the non-insane automatism being made so incredibly narrow, like, experts are going to have their opinions on whether or not this person has a mental disease or defect. The experts in this case, and this is where the dissent was upset, both said this guy doesn't really have anything diagnosable, but the Crown's doctor said there's some sort of something there that caused him to fly off the handle like this. 6 to 12 months of treatment would be enough. But it wasn't actually like a diagnosis like PTSD or schizophrenia or what have you. So the dissent had gotten pissy in that right because he's like, this flies in the face of the evidence on the record. The doctor said that there's no diagnosis, so why are we doing this?
I would have like been happy to see that no reasonable trier of fact under these circumstances could assume that this person was not in control of their actions.
They went there's got to be something there. I don't care what the doctors say. Aside from causing chaos on Cross, the law review article was also concerned that by increasing the burden so much on the defense to either overcome the presumption of sanity or even with that prove this automatism because you were like literally in danger, that it significantly reduces the state's burden to prove beyond a reasonable doubt and therefore flies in the face of the Canadian Charter of Rights and Freedoms, which is like our Bill of Rights. This guy was just not happy with how this came out.
He would be
but
a very non-defense defense attorney. But also, I do juvenile law.
Okay.
I do dependency. I wear a lot of hats. Sometimes that's a prosecutor hat. So I'm going to put on my secret prosecutor hat because also I instinctively hate the defendant in this case. I disagree with this law review article. If you're talking about presenting a mental health defense to excuse a behavior and you're trying to say that it's non-insanity, here we call that temporary insanity. And
Right.
the burden for any kind of temporary insanity defense is incredibly high.
Is super high.
You only really read about those defenses failing. I guess we could go out and try and find one where it hasn't failed. But it should be very high, because you're saying that I had a blip in the radar that caused the serious injury or death of another human being, and you should just let me walk away.
Yep.
Without treatment, without being subject to any kind of monitoring, that I'm okay with the necessary burden to that to be incredibly high. Well, we've gone through, you're going to have an interesting time editing because your case is very complicated because you had...
It is super complicated. I tried to get it like as like nuts and bolts as I could, but it was a lot.
I mean, if we're going to name this episode, let's call it Pineapple Shaped Dildo, because that's what your tooth was about.
We can absolutely do that. So next week, a case regarding a Japanese pinup model caught my eye.
And I will be telling us the remarkable true story of the actual Twinkie defense.
That popped up on my
I don't
list
have to do the Twinkie defense. I can also do it. Okay.
No, go ahead. I want
to do the Twinkie defense. It is, I mean, the defense itself is horrible, but it's related to this absolute legend, the murder of LGBTQ activist and luminary and pioneer Harvey Milk, whose famous phrase was, "Hello, I'm Harvey Milk, and I'm here to recruit you."
Awesome. So we will hopefully be back next week.